Oh, yeah. Okay, we're live. Let me just get the lighting good. Get symmetrical. Turn this one this way. Tilt this up a little bit. All right, people. Nope, that just made it worse. How is everyone doing? That's good. Okay, it's going to be a good one tonight. I hope everyone had a good weekend, has a good weekend for what is left in the weekend. We have a new member, David Glass. Welcome to the membership. Okay, let's see. Let's just do the standard intros before we get into the thick of things. Okay, live streams, super chats. Thank you in advance for the super chats. I don't get to all the super chats anymore. I do my best. I try to bring them up, even though some people say they find that distracting. I think it's the courteous and respectful thing to do. I won't get to all the super chats. If you're going to be miffed, don't give a super chat if I don't get to yours. I don't like people feeling bad. Full disclosure, I think I mention this pretty much every time. YouTube takes 30% of super chats. I know some of you out there do not like feeding the beast. YouTube, that is to say. There are other ways to support me and Robert or this channel. If you don't want to support Robert for whatever the reason, I'll get to those in a second. So YouTube takes 30% of the super chats. The live stream super chats that I get with Robert, I split with Robert. I don't think he needs it and never asked for it, but I do it because I think it's the fair thing to do. If you want to support us, but you don't want to support us on YouTube because of the whopping 30% cut, I have PayPal, I have Patreon, I have Subscribestar. But Robert and I have locals. It is called vivabarneslaw.locals.com. vivabarneslaw.locals.com. Much of it is behind a paywall for members, but the viewing of those posts is not, I don't think. Sorry, let me just get this member out of here. And it's sort of like the... It's a community. It's a community. It's nice because typically people don't sign up to berate. So you cut through a lot of the noise that you get on Twitter and YouTube. They take 10%, so it's a better platform to support us. vivabarneslaw.local.com. It's always in the pinned comment. Okay. Nothing in this constitutes legal advice. Standard as always. We're going to talk about some legal issues, but this is not specific legal advice for anyone's situation. If you need legal advice, consult an attorney in your jurisdiction. I've missed a ton of super chats already. Let me see how many I can bring up here. We've got, I can't bring it up. IT says, would both of you, V and B, like to be a member of leadership for a free people in your country? I can't speak for Barnes. I have an email, david@vivafry.com. Send me an email. I have always read emails, but I'm not much of a member type person. Dave Mink says, I'm liking and supercharging in advance. I think he meant super chatting because I know this will be fantastic. Added 30% for YouTube. Thank you very much. New member David Glass. JJ says, what can employees do when their company make vaccine mandatory? So we're going to talk about that. I think Robert and I have touched on it in previous streams, but I'll see if we can get to this one again tonight. New member Mickey the Fourth in the house. Booyah. Forced name change says, thoughts on Amazon, Alabama. They're demanding in-person voting to form unions, stating fears of... Okay, I don't want to get into trouble, but certain subjects we don't broach anymore because we don't need to poke the beast that much. Robert and I have been discussing these issues for a long time before certain new rules have come into play. Bad Vibe says, the new OCC might limit abuse. However, there are many other avenues that could be exploited by banks, payments processors that won't be addressed. Okay, let me see where we can get to, if I can get to the bottom super chats here. Let's see what we got. Mike, been watching a channel that covers Canadian politics. Amazingly and totally interesting. Highly recommend it. Which one is it? It's JJ McCullough, right? JJ McCullough, for anybody who wants Canadian stuff with a guy who pronounces a boot the way you think Canadians pronounce a boot. JJ McCullough. Longer format, once a week. I think it's still once a week. Good stuff. JJ McCullough, the way you would spell it, like O-U-G-H. Justin White says, one day and Biden is already escalating conflict in Syria. I said you got to give the new administration a chance. We're 3 days into it. The first executive order that Biden implemented was to end the Keystone Pipeline, which is going to have devastating effects economically for the United States. It's already having devastating effects for Canada. I don't know the details, but a lot of the infrastructure has already been put into place, and there's been a lot of costs incurred. A lot of jobs were relying on that. Done. We're going to see where it goes. I have questions for Robert. I have, some stuff that we're going to talk about with that. Okay, I think I missed a bunch of super chats. Let me just get another thing out there. So I've been doing, I've been following up on our curfew status in Quebec, And, a lot of the comments in the curfew videos are, why am I not suing? Why is everybody not, defying these orders? First things first, I've covered one lawsuit of a lawyer in Gatineau who filed a lawsuit seeking judicial review, which is sort of like the court's overview to determine the enforceability of the curfew orders, specific aspects of the curfew orders, not everything at large. It was a decent lawsuit, 4 pages, and it's good. There's another lawsuit by Rocco Galati, which is more pandemic related in general. Massive lawsuit. I think it's over 100 pages, close to 400 paragraphs. There's another one by small businesses in Montreal who have banded together to sue based on the unconstitutionality or the alleged unconstitutionality of the measures that the Quebec government, François Legault and the Coalition Avenir de Québec has put into place. There's only been a handful of lawsuits. And, Robert Barnes, when we talk about how to implement change, and Robert says, you file the lawsuits, even if they don't get heard, even if they get dismissed, not frivolous lawsuits like not mentioning names, not frivolous lawsuits, but you file lawsuits in the hopes that, they will get heard at some point. You file the certs, even though 99.9% of them get refused, in the hopes that one catches the eye of someone in the court and gets heard. So, there's two things. I don't think I'm the best person to file a lawsuit because of, not call it a public personality, but might not be the best person to file a lawsuit. The court might not view it with the same eyes it would view someone else's lawsuit. I'm not in the position either to represent a lawyer in this because I know what I'm good at. I know what I'm not good at. I know what I can stomach and I know what I can't. So my contribution, I think, by and large, is not to complain, but to raise awareness and to educate, because people, when they are fully informed or at least more informed, can make their own decisions. And that's what I love about what Robert and I are doing. The other thing is, I'm not telling anybody to go break the law, period. And nor should anybody do that. The people who say that typically say it from behind their keyboards. They say it when there's no repercussions for them to say it, and no repercussions if someone listens to them and goes and says it and gets arrested and gets a fine and gets a criminal record and has massive serious problems in life as a result of, doing what they thought was the right form of disobedience. It's not in my nature. I firmly believe that you change more with humor than with force, and you change more with humor than by unlawful conduct. And you change more by informing people than you do by acting in a way that is actually counterproductive. And it's the first movie reference of the night. I see Robert. I'm going to bring him in. I'm going to tone the language down because this is PG-13. Colors. We've talked about it before. It's when Robert Duvall says to Sean Penn, he's telling him the story, like Sean Penn busts down, he wants to arrest one person, scares away all the gang members. Robert Duvall says, let me tell you the story of a papa bull and a baby bull. And the baby bull looks down at a valley and there's a bunch of beautiful cows. I don't know what makes a cow beautiful, and the baby bull says to Papa Bull, let's run down there and procreate with one of those cows. And the dad says, no, son, let's walk down there and procreate with all of them. It's a crude analogy, but the idea is you can do something rash and brash and uncalculated, maybe succeed, maybe not, or you can actually be methodical, do things in a way that's actually going to achieve the ends that you want, and do it in the lawful means and the appropriate means that's going to get the reaction that you want and not the reaction that you don't want that's actually going to be used against you. With that said, people, that was my intro. Barnes is looking good. Do I? Okay, you know what? No more teasing. I missed a bunch of super chats. Sorry about that, guys. My rant went on for a little longer than I wanted. What do we see here? When will Rumble allow live streaming so you don't have to censor yourself for completely arbitrary and politically biased rules? Okay, Locals is working on it. I spoke to them last week. They should have live streaming with a form of super chat type support up and running soon, first quarter. Rumble as well, from what I understand. And it'll be great. It'll be great when it happens. YouTube, first of all, even the stuff that we have on Locals is behind a paywall. Some of the community stuff, the interactive posts. I'm going to keep all my stuff on YouTube in as much as possible. I'm going to keep my stuff free and on Rumble in as much as possible. We might have perks for stuff, for the supporters, just because that's what community is and it's what you do and you have whatever. But the bulk of this, I'm going to keep public. It's not a question of making it exclusive for the purposes of denying the very essence of what we're doing here. Let's see. Could governors use eminent domain to continue construction of the pipeline? So let's do this now. Let's get into this because I have questions. The first of which is going to be starting with executive orders. but the first of which is going to be bringing in the Barnes. Robert?
Good.
My computer is on mute, so let me just take it off mute. Okay, can we try that again?
Good.
Okay, good. I got it. I'm an idiot, people. Sorry. Okay, volume's good. I hear Robert. How you doing, Robert? Everything is well where you are?
Relatively, yeah. It's supposed to snow apparently tomorrow in Vegas. That'll be interesting.
Okay, now you've just piqued my concern. You said relatively. What's?
Oh, I'm just a little under the weather, but that's all.
Okay, good. Nothing too serious. A cold. Nah. Okay, and now I see. Let's get the first book out of the way before we get to the second movie reference. What do you have behind you this week?
So yeah, the one this is The Devil's Chessboard, about the Dulles brothers, the rise of the weaponization of intelligence, and the rise of the deep state in the United States, in the national security apparatus. And it's just a good book about the early CIA and all the kind of mayhem they helped create and the institutions they helped sort of lay the foundations for. And then this one is the Contours of American History by William Appleman Williams, who was the professor. He was the professor of my professor. He was the guy that gave the doctorate to my professor at UT Chattanooga, Larry Homer Larry Engel, who called himself the founder of the Redneck Anarchist Club. And it's still, he's sort of an old lefty, but with some strong populist instincts, varying degrees of vitality, depending on how much of the New York Times he's been reading lately.
Okay, that's you got your first book out there, everybody. Now you know what you have to read this week. I've just started Black Rednecks and White Liberals, Sowell, but I'm going to see how far I get into it. I have not had time to listen to it on Audible. Peep Chat Noir says, please tell Barnes Esquire that my local bottle shop has some 23-year-old Pappy Van Winkle for 3,400 Australian dollars. Happy to be a go-between if he's short on Pappy VW. Okay.
Pappy's is great. Pappy's hard to come by these days. Old school bourbon.
What does 3,400 Australian dollars translate into? That's a lot of money.
That I have no idea.
I think that's close to that's about the same Canadian.
Oh, really?
Okay, Robert.
What is that? Is that like $3 Canadian to every $2 US, something like that?
Yeah, let's see. I'm going to see if anybody's going to give us an answer quickly in the section. No, nobody is. Okay. Actually, first things first, by the way, if there's spamming in the chat, that might be a cause for suspension. So don't spam, and don't, be courteous, but don't spam, because I put it on 30 seconds, not so that you can spam every 30 seconds. Robert, let's start with the first issue. First question tonight, the executive orders that came out of the Biden's first, I don't know, how many hours in office. But the first question was, someone had just asked also, executive order versus executive action. What is an executive order? What does it require to become enforceable? And what can go into overturning an executive order that undoes something that was hitherto done? First question, what's an executive order?
It's really just that the executive branch has certain discretionary authority in certain areas of enforcement. And it's just the president codifying that and sort of clarifying it for the rest of the executive divisions within the executive branch of government underneath the president's control. So that's loosely all that it is. It's become very popular because it's become sort of symbolic. Obama really used it a lot after he lost the House and Senate. And Biden set a record. He did more executive orders after getting elected president within 24 hours than anyone ever. I don't know if that's a great achievement, really, but ideally, a good executive order is just clarifying executive direction. A questionable executive order is one that tries to be substitute legislation.
Okay, so that is, I guess, the main issue, because the executive orders. I mean, whether or not I'm a fan of them ever, even under Trump, when he did the executive order as relates to social media, everyone's like, okay, it's a good executive order, but it doesn't have any actual impact. So the executive order, in order to be turned into something enforceable or something an actual directive, what is it? What's the next step that would need to happen in order for the executive order itself to become law or a form of enforceable action?
Well, really, constitutionally, ideally, all that an executive order is like the captain's directive to the lieutenants in the police department. Here's going to be our priorities this week. Here's where we're going to focus. Here's how we're going to achieve that, etc. So ideally, that's all that a constitutionally compliant executive order is. And there are certain areas where an executive order is within his discretion. So, for example, this was one of the questions on the locals board subscribers as well for tonight's session was about the pipeline.
Yep.
And the thing with the pipeline is the reason why that requires presidential approval is it's across the U.S.-Canadian border. And Trump set this up. Trump established that the permit was contingent and could be revoked at any time by any president, himself or future. So that's why there's not much they can do legally. It's a cross-border pipeline. And the problem is, I mean, yeah, you could build the pipeline on this side or the Canadian side without ever connecting the two, and without needing presidential permission. But you obviously need presidential permission to connect it, and only connecting it gives it its value. And because it was an executive order, not a treaty, not a binding treaty, say with the Canadian government, it was not a law that was passed. It was not necessarily a binding contract that was agreed to, and even to the degree they're going to argue due process, and they will sue. I mean, the government, Alberta government, will likely sue. The companies involved will likely sue, but they're not likely to get anywhere because even under Trump's agreement to allow it, it was contingent, and it had a provision that it was like one of those trusts that you can revoke at any time. Like a revocable trust. And that's not really, there's not much you can do to make that legally enforceable. You take the risk knowing that can happen at any time. And Biden on this issue, now not on some others, but on this issue, he'd been pretty clear he was going to revoke it if he won.
But so the idea, this company will have invested, I don't know what stage they're at now, or these companies, it's JV, whatever. They've invested tons and tons of money and time into this. Out the window? I mean, or is it going to be a question of renegotiating with the government and finding an alternative method so that Joe Biden can then issue another permit and save the project after he's done certain things to ensure it'll be compliant with X, Y, and Z? I mean, is that what would be on the books?
Well, they've been basically fighting litigation now for a dozen years on this. So I think, though, my guess is they walk away. Alberta and some others will sue. They may sue under NAFTA, but the U.S. has never paid any damages under NAFTA. And there's parts of the way NAFTA was reconstructed that makes it difficult to get money from the U.S. for a violation of a trade agreement provision. And so I think that most lawyers who have looked at it don't think they can do much about it. It was always a big gamble. And the reality is they needed to get it started, to get it built before a president could revoke the permission in a meaningful way. And they didn't.
Okay, well, so I mean, and the amazing thing is, setting aside the legalities, because I would imagine they're going to argue, we call it droit acquis, or acquired rights, or some wrong where they've invested time, money, infrastructure, employees, all to have it arbitrarily, unilaterally revoked, even if it was a campaign promise that he's following through on. There will be litigation, see what the courts say, but okay.
And honestly, it was the way Trump structured it. If Trump wanted to protect that pipeline, he needed to do a different deal. He put in the deal so that a subsequent successor president could revoke it overnight without a problem. So that they can't really say, well, we invested this money believing this would happen. Yeah, but you also agreed that they could revoke it at any time. And so when you have that kind of clause, it's kind of it's an uphill battle legally.
Yeah, and the thing that I found most remarkable about it was how the response from the Trudeau government. It exemplifies this political confirmation bias, where first thing that comes in is Biden takes an action which, by all accounts, would cost at least 11,000 jobs. Some people saying that those would have been temporary jobs, to which I might respond, a lot of construction jobs are temporary project-based jobs. And then you forget about the incidental job creation that would have occurred around those jobs. Set all that aside. Biden comes in day one, does something which is going to adversely affect Canada. And the response, because we want to like the administration, is we're very disappointed, but we look forward to working together with you on other issues. Whereas had this been someone else, it would have been screaming bloody murder until the cows came home, to mix a number of metaphors. Yep. So, okay. So we'll see. An uphill legal battle probably won't get anywhere. The issue might be renegotiating, or those in charge of the Keystone Pipeline. I was listening to a few interviews. Now they're saying the project now is different than what Obama opposed before Trump, and it's different than what Trump approved. So maybe they can succeed in convincing it's changed enough to have some sort of conditional or new permit issued, but we'll see where that goes. So,
I mean, I think there's some talk that they're just going to walk away from it at this point.
And then
So that I think though it may happen just because they're tired of it.
what happens to all the pipeline that's been laid or that's sitting around waiting to get laid?
Yeah.
So, an executive order then, what are some of the more problematic in law executive orders, not politically, legally problematic executive orders that Biden has just issued? The mask mandate, is that a problematic one?
Well, there I was curious because I was looking at ways to sue right away, and his executive order on mask mandates doesn't actually mandate any mask. There's one that kind of does, but what he really says is, "Hey, cabinet secretaries, please look at this and issue your own mask mandates for the areas under your jurisdiction." And so he didn't really issue a mask mandate. It's part of why he could violate it that night, not wearing a mask inside federal property, even though he has called for a mask to be required in federal property, also for it to be required in a wide range of interstate travel, federal parkland, things of that nature, but with a lot of caveats and exceptions potentially built in. So they may have anticipated that suits would come quickly on that issue. So effectively, there is no enforceable mask mandate yet. It will probably be months away, maybe sooner, but usually the government moves slowly when it goes through its regular process. So that particular one, he dodged the bullet mostly because he didn't actually impose the mandate that it looks like he's imposing. He's simply asking these other cabinet people to do something, kind of like Trump's Section 230 executive order in that respect.
Okay, interesting. And the question that I was going to ask, for those people who hear the term mask mandate and don't actually understand what it means, and even I have difficulty understanding this. Who is issuing the mandate? Who is giving the mandate? What is the idea of a mandate from the government in general?
So what really that Biden is looking at is not allowing you to travel between states in certain forms of travel, airlines primarily, not allowing you into federal buildings, not allowing you onto federal property unless you're wearing a mask or you're exempted from having to wear a mask. The exemptions are not carved out yet, but that authority was given to the individual cabinet officials. So ultimately, that's really what it does. And then usually the mask definition is pretty broad. It can be, usually at least by the mask mandates we've had so far, both around the United States and around the world, have allowed for cloth masks, bandanas, those little plastic shields, all those kind of things. So and as people like Alex Berenson, who was recently on, or about last month, was on Joe Rogan, detailed, none of those masks have had any effectiveness at all. But the reason that's what makes it all about for show. The mask mandate is please show your compliance. And as Alex Berenson pointed out, is if your point was to show that you're sick, that point is defeated when everybody's required to wear it, not just sick people. And so there's still a lot of there's little evidence of asymptomatic spread. So that makes it very problematic that we're requiring people who are not sick to wear masks. There are consequences. There can be adverse health consequences to wearing masks. We've already seen discrimination against the disabled, even though they're exempted from mask wearing because it's not being recognized by stores and by members of the public. People who get panicky and start having anxiety attacks over what other people are doing. So there have been a lot of problems, and I think the evidence would show that there's not a good, sound constitutional basis to require a mask. And so as soon as those cabinet officials ultimately put through the rules, then there may be people willing, ready, and able to challenge those mask mandates, along with other mask mandates, because the evidence continues to shrink and diminish as we go along.
And there may be
my old ally, who writes for the New York Times, recently was shocked that when he was out traveling across the country, he's now one of the economic editors at the New York Times. He was shocked to discover all these people not wearing masks. And, I just tweaked him a little bit. He was the editor-in-chief of the Yale Daily News when I was there, put my protest organization on the front pages. So, so I don't attack him I don't really attack him. I just tweak him now and then. But he found that horrendous because he said all the studies show that masks work. And it's like, well, you might want to go back and reread those studies. And you might want to just listen to what Fauci said and what everybody was saying back in February and March. when they didn't want people wearing masks. So the evidence does not stand up in support of this mask mandate. And it's an area that's questionable because theoretically, though, OSHA, what it is he gave it to all the different cabinets so the cabinets could come up with their own regulatory pretext for issuing this, because he knows the president doesn't really have a pretext for issuing it. And he's limiting it to federal property. The most risky part is the interstate travel part from a legal perspective. What you do on federal property, what you do on federal buildings, what you do for federal employees, that's one thing, though there's still union agreements and other things that have to be governed by it. But it's quite another if you try to mandate it beyond that. He's not trying to go beyond that. He's giving each cabinet official an opportunity to explore what pretext they can come up with to mandate masks under their particular jurisdiction. So we'll see what somebody's going to go too far and make it easy to attack, hopefully. And we'll find some places to sue, and we'll likely be bringing suit. But the mask mandate executive order is not yet a real mask mandate executive order. And had it been so, it would have been challenged pretty quickly. Whether what the courts do is an open question, because you have all these courts that are in panic mode requiring, you'd have to be arguing that the mask mandate is irrational while wearing a mask. This is the insanity of it.
Now, I've read some studies. There's a certain logic to the masks. I mean, anything that could, in theory, prevent some form of aerosol spread. I mean, logically, it would. There's some barrier there, some additional barrier that is not otherwise there. So there's studies back and forth, and you're going to get into an argument of authority. The question is, even if it becomes mandatory, these exceptions that are provided for in law, which are not respected in reality. So on the one hand, asthma, on the other hand, panic attacks, psychological reasons, respiratory, non-infectious disease, respiratory issues. And then it becomes an issue of potential violations of disclosing confidential medical issues, psychological issues, and B, it doesn't even seem that people care once you're out in public mode, airlines and private enterprises, Trader Joe's. What's the deal? Has there been any advance on the Trader Joe lawsuit?
We have some suits that we have filed on discrimination grounds and that are in the process. They're still at the earliest stages. Some companies have backed down, some have not. And so the ones that have not, those suits go forward. Robert Kennedy's organization is working on bringing suits against educational institutions related to compelled vaccines and mask mandates. And so it's continuing to expand in different places. But from an evidentiary perspective, the argument for wearing masks has gotten weaker and weaker and weaker in terms of mandatory masks. It's one thing to say someone who is sick or may be sick should wear it. It's quite another to say everyone should wear it. With people who've had it and recovered, who clearly can't be spreading it.
I mean, that's
things like, there's so many insane provisions of this rule that may, and not only that, it's only the N95 masks that have shown to be very effective. The rest have shown not to be really effective at all because COVID is too small a particle to block out. And so there's a lot of, and there's problems. Like what should happen is they should go through and do an investigative review, have a notice and comment period under the regulatory structure. Ideally, this should go to the legislature first, then the regulatory structure, then get approved in the judicial structure. All the things they required before Trump was allowed to pull out of the Paris Accord the first time, that they're not doing, and trying to require that this medical Sharia law be imposed on everybody. So that's the process is as problematic as the substance in this instance.
No, I mean that's one thing I've never understood is if there's a certain antibody period where people who have gotten COVID and recovered, logically there could be no real reason while they're under that antibody protection type situation to be forced to wear masks. And then another thing that most people don't fully appreciate is that there's various types of masks for various types of reasons. The one for surgery was to prevent saliva and sweat from dripping into a wound. And then the N95s or the other, spray painting masks were to filter out the air before coming in. But so the idea is if there's going to be a mask mandate and they're going to compel, I guess the idea is, first of all, can the federal government compel the states to do anything?
No. All they can do is they can compel, they can control federal property, maybe interstate travel, but that's a little bit risky about how far they try to go in that regard. So, because there is a right to travel between the states. So they can't really burden that too much. So the airlines is probably where they have the most flexibility. Anywhere where Homeland Security exists, that's where you could have a mask mandate.
Okay.
in terms of federal power. That doesn't make it constitutional yet, but in terms of federal power.
Okay. Super chat was missed. Who said this? Cheesemaker Keezy. I don't know what super chat it was, but I'm going to miss a lot of them. So heed to the warning in the beginning of the stream because I can't get to all the super chats. That's what I said. What I was going to say now. So go ahead.
I was going to say the most problematic executive order is legislation ones that directly breach a treaty, existing law, or an agreement. And that's particularly the case in the immigration context. So Biden apparently intends to reactivate DACA. That means all the old DACA lawsuits will be reactivated with it, which the courts had been sitting around, the Supreme Court in particular had been dodging. And now it will open up that can of worms again. And then finally, the Republicans sort of learned from Democrats what Democrats did throughout the spring and the summer of doing private legal agreements to get around the legislature and how the election was structured. Well, the key immigration officials associated with Trump on their way out signed agreements with the state of Texas as about how they would manage immigration. Well, those are separate binding agreements. So that'd be like, if they had in the Keystone case, if they had a binding agreement that's what they should have done, frankly, to try to make it difficult for Biden to back out of it. But in the pipeline context, but here in the immigration context, they had an agreement to abide by certain limitations and basically just enforce the law in the books because of how immigration can impact the state of Texas, especially. And Biden just decided to ignore that entire thing. He went in acting like no such agreement existed, pretended it didn't exist, decided he was going to ignore all the laws on the books. And that's not really executive discretion, which is the theory that DACA was passed under, and it's always been problematic because it was never legislatively authorized. Here, he's just saying he's not going to enforce the law, period, for 100 days. And so that's clearly not within his constitutional authority in the executive branch really to do, especially not within his contractual authority, given the agreement they had with the state of Texas. So the Texas should win that suit, with federal courts, as we've seen and saw in the Amazon case and other cases, it's a crapshoot. But immigration is one place where when it's the state suing, the Fifth Circuit and some of the federal judges down there have been reasonable and have actually enforced the law. So we'll see. But I think Texas has the Texas versus Biden might be one of the first big wins for the state and for states in general to push back against Biden trying to usurp legislative authority through his executive orders. And that's the most problematic aspect of executive orders, even more so than what people think his rejoining the Paris Accords mean, which is a separate issue.
On the Texas executive order, I mean, do I understand it correctly? It's basically saying we're not going to enforce immigration law for 100 days. A, how does that work? And B, pending what? Like, what's the rationale? How would that even work? We're not going to enforce immigration laws for 100 days.
I mean, it was not only that, it was deportations where no one had any rights left. They'd already had their hearing. Everything had been done. It was clear they're supposed to be deported. The only thing that was supposed to happen was their actual deportation. And he just suspended it. Just said, we're not going to enforce any immigration laws basically for 100 days as it relates to the deportation context. And it's like, what? And this is while there's this is the message that's gone out as the big Honduran caravan coming up through Central America, coming to the U.S., as they told interviewers and reporters, they felt that the reason why they were doing this was because they had got the message that Biden said you had 100 days to get to America. And if you got there within 100 days, free health care, free education, and free citizenship are going to be available. And he reinforced that by what he did with this executive order. And so it shows that he really is committed on the immigration context, even though immigration turned out to be a Democratic loser amongst actual immigrant voters this last election cycle. I mean, Trump did better amongst immigrants and did better amongst Latinos than any Republican had done maybe ever. And so people were curious, would he continue with sort of the wokester immigration agenda in that context? And the answer is absolutely. And he's being much more aggressive than Obama ever was. And so it's going to be interesting.
So Texas is suing, or Texas has announced that they're filing suit, or have they filed suit? What's the nature?
Filed suit. They filed suit. They're seeking an immediate emergency injunctive order this week.
Okay. And so there's been no judgment on the emergency injunctive order. Practically speaking, let's just say 2 or 3 days lapse before you get, even assume it's a favorable judgment, but before you get any judgment, the practical effect of the executive order is that anybody who is slated for deportation for whatever the reason it's not going to happen. If the judgment comes back that overturns the executive order, does it resume, or did they just get a window and now they have to go through the whole process again?
No, then it would resume as if the stay never existed.
Okay. So we'll see we'll see if and when there's a judgment. Is there a hearing, or is it just written briefs for this? Has there been
up to the court? Court may hold oral arguments, but this is now an issue that's gone. The federal district courts in Texas, the federal appellate courts at the Fifth Circuit, they've been dealing with this for almost 10 years of Texas and the feds going back and forth at each other over immigration controls. Ever since Obama decided to try to do DACA, and even before DACA, try to mess around with different immigration limitations. And so that's going to continue unabated. But that means they're more familiar and more ready to act than they would be in other contexts. So that's why I think Texas has an above average chance to get their relief granted.
And if the relief is granted, does the administration nonetheless pursue with a final, do they abandon the executive order altogether and thus render the lawsuit moot, or do they fight it on the merits and say we have the authority to do this? Or as a total, I guess, alternative solution, can they not just pass a law through the legislative means to basically legitimize?
Yeah, they know they'll never get legislative approval for what they're talking about. Nobody's really interested in, not enough people. They're nowhere near a majority in either the House or the Senate for halting deportations, for reversing deportations, for changing deportation rules. So especially because most of the people that are currently being deported are really not people that they want to use as poster boys for immigration. And so on average, there's some exceptions in there, but there's plenty of some egregious cases. And some of those egregious cases they're allowing to go forward, but only the most egregious. So I think they could try. Now, I do think they plan on trying to do amnesty through Congress and some form of codifying DACA through Congress, but they want to expand that into full-scale amnesty. He did back off his initial position of immediate amnesty, and now he's talking about proposing amnesty over 8 years. So we'll see what happens. So I think that they want amnesty to count before the next census. That's the goal, and to have that impacted in all of that. So that's another place where it will have an impact, and we'll see how it unfold. But the Texas case will be big about how much carte blanche are the courts going to allow Biden to have for immigration. Or will we have any enforceable immigration laws, or will they be up to the whim of Biden? And secondly, are the courts going to push back on Biden, period? Or are they going to take a radically reversed position compared to how they constantly intervened against Trump? So this will be highly educational right out of the gate as to whether the judiciary will be an ally of protecting sort of the constitutional framework of government, or are they just also partisan and political, that they're like that judge in the Amazon case to where that's all that matters.
We're going to get there. I just want to bring this one up. Mark Walford says, Viva, what really annoys me is the person who wears a mask but does not cover their nose. There was a funny image going around Twitter that said wearing your mask like that is like wearing your underwear with your ding dong hanging out of the front. That doesn't, like, I know what the masks are for and how they're supposed to be worn ideally. What someone else had said, people constantly touching their masks with their open hands. That's another thing that I found counterproductive. I saw some hilarious things, hilarious in the ironic, sad way that people pulling their masks down to pick their nose, to spit on the street, to smoke a cigarette. And coming out of the inauguration, Gretchen Whitmer, people are supposed to wear masks, following the rationale when they are unable to social distance. Yet people are wearing the masks as though it's the excuse now to go deliberately pose for selfies that are totally unforced under the circumstances. It's counterproductive. It's whatever. There's no words for it. It's ironic, and it's not the right word.
No doubt. And Alex Berenson also has 3 good books out. I think it's like for $5.99. You can buy all 3 together about the truths about the lockdown and the truths about COVID. That are good. I mean, Berenson was a reporter for the New York Times for a better part of a decade. Then he wrote spy novels for a decade that made him independently wealthy, so now he can say whatever he wants. He was on the panel with me at Hillsdale College last year when we discussed a lot of these issues. But he does a really thorough and in my view, conscientious job. In other words, he doesn't come at this from any political perspective, leans slightly liberal, but sort of an old school moderate liberal that doesn't really exist much anymore in political representation. But that's what he represents. So he's not coming at this from a anti-mask, anti-lockdown, anti-vaccine perspective, just an evidentiary perspective. And what he said is he wouldn't wear a mask. He doesn't think it helps. He said he would not allow his kids to get the COVID vaccine because he doesn't think it's safe and effective. And he thinks the lockdowns have killed far more people than the disease, than COVID has, which a German court, maybe a bridge to that case, a German court confirmed this week. When we see these courts do what Judge Stickman did from the Western District of Pennsylvania and actually hold hearings and actually preside over real evidence, they're often coming down on the same side that Stickman came down on. And this is a third or fourth court around the world to come down to this conclusion. Said, look, the lockdowns are killing far more people than COVID is. And that the lockdowns are far more dangerous to freedom, liberty, financial futures, psychological and mental health, and to just being able to be alive than COVID presents. And so it was a nice, there they use the international human rights standards. So we're seeing courts around the Western world start to push back against some of the excesses of the lockdown era. And that decision was a well thought through decision. There's a link that has the English translation of the decision up. And it was great to see another case in another place of another court being willing to step into the breach and push back and show the evidentiary record does not support the reasons these politicians are using and giving for these massive invasions and incursions on constitutional liberties.
Now, in fairness, I should disclose the unfavorable information as well for all the good that has come out of Germany for, in certain respects for respecting rights as relates to that judgment. Germany, from what I've been told, is also apparently planning detainment centers for people who refuse to quarantine or for people who have been diagnosed or refuse to get tested.
That might not be the first time the Germans have come up with that idea.
Because I in one of my videos of Viva on the Street, I was saying, it's amazing. In Quebec, we're going into curfew now, even though our own health director said that there's no scientific concrete evidence to support the effectiveness of curfews. Notwithstanding, we're imposing one. Some people are taking it to the courts. We'll see what the judges say. I mean, I haven't grown skeptical. I've just grown to expect what the courts are going to say. Nobody wants to be the judge. Nobody wants to pull a Stickman, really. Nobody wants to be the judge that will bear potential responsibility. They're going to say, you killed grandma. So I don't expect the courts to do much. But
the lockdowns are killing grandma.
And not just that. It's an anecdote that I don't share often, but my grandmother-in-law passed away, not from COVID. I'm fairly certain just gave up. She was 95 or 98, spent the last 9 months of her life effectively, isolated from family. We got to visit a few times after the most serious lockdown restrictions were in effect. But, what's the point of living when you can't even see your family? But all that to say, so we'll see what the courts do. But when I was complaining about the imposition of a curfew in violation potentially of constitutional rights, given that its effectiveness has not even been recognized by the people imposing it, I said, in Germany, they are able to do rapid testing. You get a result in 15 minutes and it costs 40 euros. And then everyone in the comment section is like, whoa, maybe Germany's not the best example to be following because apparently they're setting up detention centers, whatever. The issue about people who are test positive and who refuse to quarantine is a separate issue. And there was a case in the US that touched on that. There I can understand people who are positive, confirmed positive, refuse to quarantine. Okay, that I can understand. But
the only thing there is if they're asymptomatic, these PCR tests that are, I'm starting to look into this for looking at different lawsuits that we're going to be looking at as it relates to masks, as it relates to vaccines, as it relates to these detention camps, as it relates to lockdowns. And even the tests appear to be highly questionable in their reliability. So that I think that if they have someone that's symptomatic and has tested positive for COVID, then the old traditional quarantine laws likely allow the government to require self-quarantine. But if they're not symptomatic, if they're in fact asymptomatic, aside from the fact that there's no evidence really that asymptomatic people truly spread, that turned out to be mythology, as some of us were talking about at the time, is there's no history of these kind of viruses having much high risk of spread from asymptomatic people. So aside from that issue, and that's the basis for quarantine, not for your own health, but for others' health. But the other issue with asymptomatic is you may not, in fact, have it, because the way these PCR tests are designed, they really weren't. Apparently, the guy who helped create some of the testing said they weren't designed to be able to accurately identify viruses in the body. He goes that they were designed for other things. And so there's real questions about how reliable and accurate these tests are at identifying. And we've had some famous, well-known people who tested positive and turned out to be wrong.
That's the issue. That there's false positives. There's potentially false negatives. The cycle rate for the PCR tests have been increased potentially. I mean, there's I know where I'm venturing out to that which I don't know about, but I know the questions that even the scientists are asking and people who know more than me are asking. And incidentally, I just want to bring this one up. Lionel de Grandpré says, lost my mom Christmas Day 2013. I thank God she didn't have to go through all of this. Sorry for your loss, brother. My grandmother passed away in November before all this happened. We had a proper funeral. I mean, and I say, she was 103, by the way. My grandmother was 103, passed away peacefully, lived a life, the only tragedy of her life, I think, was that she lived longer without her husband than she did with her husband, because he died 30 years ago. But she passed away 2 months before all this happened. We had a proper funeral. We mourned properly. We mourned like humans are allowed to mourn and supposed to mourn. And the amount of people who have been deprived of that, I don't even call that a fundamental right. It's a human need. Is enough to make you to make you feel sick.
Yeah. And it looked to me like the Quebec suit was a very logical, rational suit. I think your phraseology, that it was short but sweet.
Short and sweet. Don't ask for the sun and the moon. Just ask that, hey, if you're imposing a curfew, what rational connection is there to walking alone at night in a manner that doesn't require coming into contact with anybody? If you're going to violate rights for an urgent cause, it has to be as minimal a violation as possible to be constitutionally justifiable. The second you start putting people on house arrest while simultaneously acknowledging that there's no concrete scientific evidence to justify the measure, in my mind, there should be no court in Canada, Quebec, that should find that to be a constitutionally justifiable violation. But we'll see. So far, the courts are not rushing to hear that case. They're not rushing to hear the other case, and people are not rushing to court because it's not a pleasant thing. It takes time. It costs money, and people get discouraged because they see the way it's gone all too often on other issues.
Well, it's sort of a good bridge to when we see. I mean, the way I put it is, when we have the people in black robes telling us to defer to the people in the white lab coats, that's not a good combination. And another variation where we have that is in so-called climate change politics. And that's really what the Paris Accords are all about. And there's some confusion because the Paris Accords are described as a treaty in international law, but they're not considered a treaty under the United States Constitution in all likelihood, though that's an open debate because, as people have pointed out, Newsweek did it could be another one of your fact checker videos. Newsweek did a fact check, second guessing Congresswoman Bobart's opinion, which she said, I'm not going to support, Biden shouldn't be allowed to stick us back into the Paris Accords when the Senate has never approved that as a treaty. And they did a fact check where they said her fact was false. When it's purely a matter of legal opinion, it's entirely disputed. It's not it's not a fact, period. Well, her statements that were factual were completely true. The Paris Accords have never been approved by the United States Senate in period. Number one. Number two, all treaties that are actually treaties under the U.S. Constitution have to be approved by the Senate, or they're not treaties under the U.S. Constitution. Also factually true. And so for them to say, oh, she says this, but our interpretation of the law is it means that it doesn't mean what she thinks it means, and thus the fact check is false. I mean, these Newsweek is just lying. Newsweek's going to get sued in some other cases. It's just they should quit. They should get out of the so-called fact checking business entirely, because whenever I see fact check by any media institution, I know here comes another lie by the media.
it's beyond anything, and you can't fact check a legal opinion. I mean, it's a matter of fact. You can negate, you can contradict it, you can argue with it, but stating a legal opinion cannot be factually incorrect until a judge has determined that it is factually incorrect in accordance with.
Even then, that would just be a judge's opinion.
Well,
so it's the idea you can fact check these things is absurd, and the facts that she talked about were true. Their Newsweek is lying to its audience to the extent that they're trying to say that the facts that she talked about were not true. Because the two facts, yes, a treaty has to be approved by the Senate, and no, the Paris Accord was never approved by the Senate. Those facts are true, 100% true. And Newsweek almost lies to its audience by implying that those facts are not true. So if you would have to read the whole article to know how Newsweek is lying, because they know most people just see fact check false, go on.
I might have to break this one down, but so let's. I guess this might be a good segue if we're talking about. We'll come back to one of the executive orders afterwards, but if we're coming back to court of law,
this is kind of one of his executive orders is re-entering the Paris Accord.
Okay, so let's stick to the executive order. Well, what is going to be the impact of the executive order of re-entering the Paris Accord? Does it get challenged?
Well, here's why it's all symbolic. So the Paris Accord, Obama administration knew they would never get approval for the Senate. So they wanted to make sure it was not legally binding. So they designed the Paris Accord so that, frankly, it's all unenforceable. It's all, we promise to do this, we'll disclose this, we'll report this. But it's basically what they call in the law an executive agreement on the U.S. side. Now, in international law, any agreement between countries is basically considered a treaty under international law. But under U.S. law, it's not considered a treaty as long as it's not binding. And the theory for that is the treaty and the U.S. Constitution are the supreme law of the land. To give you an example, once a treaty is passed in the tax context, Congress can't change it. The IRS can't change it. That's why the biggest tax loopholes in the world are tax treaty-based loopholes. That's where things like the double Irish and the double Dutch involving transfer pricing and intellectual property that Facebook and Apple and Google used extremely effectively to pay almost no tax. Same with Amazon. Nobody could do anything about it because it was part of the treaty signed unless you had to renegotiate the treaty and pass a new treaty. So treaties are the supreme law of the land other than just beneath the Constitution itself. So that's why it matters. So Obama knew he could never get it through. So he agreed that everything was pretty much voluntary other than reporting and some other stuff. But basically, it's not binding law. So all it really is my administration, as long as I'm in as president, agrees with these principles of other countries, and we're going to work with those other countries to achieve certain things. But it's nothing that's legally binding. So it has no real impact. The Paris Accords were always much more symbolic than they ever were substantive. They never really, and in fact, that's the part of some of the critics of the Paris Accords from both the left and the right, is that they're mostly symbolic, not substantive, because one of the biggest breachers of it is China. And China knows that it doesn't have to worry about it because there's no enforcement mechanism meaningfully in place. So that's an example of an executive order where Biden does have the absolute authority because it's just an executive agreement. It's not a treaty, and it doesn't mean anything really. It's more symbolic than substantive in its outcome.
But then the U.S.'s contribution, its obligations under the accord, there are going to be let's just say contributions to certain objectives, reduction of certain emissions.
Even that, they don't have to give the money, and there's no enforceable mechanism. So it's like if you and I agree to that we're going to only use 1,000 kilowatts of whatever this year, but we have no agreement about what would happen if we don't do it, and it's not binding, and there's no court in place. Is that really? That's more of, hey, that's more like a goal than it's not a contract. So that's why it's not. If it had been, then it's unenforceable because then it is a treaty, and he's got to get Senate approval.
And I'm bringing this up. Randy King right on cue says, don't treaties require 2/3 Senate approval? Couldn't Dems avoid it with budget reconciliation?
They can't. That's a constitutional requirement. So There's no only way to make treaties the supreme law of the land is to have 2/3 approval by the Senate. So you get that, you don't have a treaty, and all you have is what they loosely call executive agreements, and those are like any kind of agreements. Those are like, okay, we'll agree over the next 4 years, we'll produce less missiles if you do, Russia, things like that. Now, if it's going to be an actual treaty like START or other things, then it has to pass the Senate. But and then it's binding on the country and it's binding on future administrations. The thing with both the pipeline and the Paris Accords is neither one was binding on future administrations, and so it was sort of broad executive discretion. The president could give or not give the permit. President could say, yes, we're going to try to do this or not try to do this. But him saying he's going to try to do it, so what? Until the only thing that matters is what Congress actually passes. And he could say, let's do this in honor of the Paris Accords that we've all agreed to. It's like I said, it's more like a goal. That he said, here's our goals. That's all he said.
Okay. So we'll see if that quells anybody's concerns, but here are the goals and whether or not they get the backing to actually make those goals.
Yeah. Still is another whole hurdle he has to go through. And he's not going to get to most of them. Because again, I mean, he's getting blowback because the other executive order he did, and here again on federal lands, he's got some broad discretion, and he's got some, a lot of, his permission, the president's permission is required in a wide range of these contexts. And his decision to, after saying, don't worry, I'm not going to really ban fracking, he basically started banning fracking, various forms of it. And now he's getting blowback already from places like New Mexico, because they voted for double digits for Biden, but I guess they didn't figure out that Biden meant what he said. And now all of a sudden their schools are going to be underfunded, their roads are going to be underfunded, their infrastructure is going to be underfunded, their police is going to be underfunded because they depend on those new leases on federal land for gas and oil in order to fund all those things. And so we'll see what happens. But he was always going to deliver on that side of the aisle politically. Too big of an issue in the primary stage. The question is, how much political blowback do congressmen and senators and other people start to feel? And I think that's why he'll have trouble actually passing much of this. He can do what he can on the executive side, which will make an impact. I mean, killed maybe 100,000 jobs in a week. I mean, congratulations, Joe, on that. So, I mean, but that's about, there's limits to what he can get away with over time in terms of what he needs legislative approval for ultimately.
And not Dershowitz, Cernovich has been, I won't say ruthless, but he's been quite honest and vocal about, you get what you vote for. And when you vote without fully appreciating the substantive issues behind the candidate you're voting for, and you're voting based on candidate and not policy, and then you wake up the next morning to see who you're lying in bed with, and you may not like it, that you get what you vote for. I mean, it's not just a U.S. thing. I mean, we're getting what you guys voted for in terms of the Keystone Pipeline. We're going to have to literally pull pipe out of the ground. You got 150 miles of pipe that's never going to get laid. We'll see what you can do with it. New Mexico, Pennsylvania, I understand, are also having buyer's remorse potentially, or at the very least, according to certain people on Twitter, in that they're seeing now immediate repercussions of their choice in candidate from an economic job perspective, coming for loss of unionized jobs where the unions told people who to vote for. So hurt union jobs, hurt the energy industry, is allowing mass immigration to occur potentially. A lot of the things that he kept low key. In other words, he pretended he wasn't going to end fracking on federal property when he always was, and now is doing so. He pretended he wasn't going to be a complete open borders guy, and now he quite clearly is moving in that direction. Pretended that he wasn't going to do things. I mean, another example of where it's highly problematic is that basically he decides to reopen certain infrastructure investments up to China. And it's like, okay, you're already thought of as China Joe in certain circles, and one of your first actions is going to be that. So, and then otherwise he just comes out and says, by the way, we've all been gaslighting you about COVID. I don't got any plan for COVID. Nobody's got a plan for COVID. It's just, there's not much we can do about it. Just going to keep going. Virus is going to virus, which a lot of us have been saying that it was always going to be the case anyway, that most of this was for show. But, some people were shocked by that. They're like, oh, they bought the media nonsense for a year that you could truly control a virus like influenza.
No country in the world has ever controlled a virus like influenza, but somehow magically, if Donald Trump would have just done one or two things differently, we would have.
No, but
now, of course, the cat's out of the bag.
What drives me nuts is when Biden is now talking and saying, if Trump had done this, 50,000, he would have saved 50,000. If he had acted a week earlier, that's not even Monday morning quarterback. That's like Monday morning retroactive, predicting the future of the past that never happened. That drives me nuts, because that is not just
you'll see that suddenly disappear. I'm sure CNN will stop having those running numbers on the side of their little broadcast each day about the number of people who died. Watch that suddenly slowly vanish. Now that's not Bill Gates' agenda, so we'll see who wins out in the end. But it makes Biden look bad. So all of a sudden, my guess is they'll start studying, figuring out the problems with the limitations of testing, start changing how it is they determine cause of death in COVID cases. You'll start to suddenly see the numbers magically fix, and we'll see if they go down that path. There's people who want the forced vaccination agenda who are going to keep pushing the panic porn. But the Biden administration doesn't want that. Biden wants it to look like he's magically cured everything just by showing up and not being Trump. So we'll see how well that works. But he started pushing a lot of policies that are really not that popular. He didn't win on any kind of platform at all. My guess is if you asked Biden voters, 2/3 of them wouldn't even know what his platform was. It was he's not Trump. That was it. He's not Trump. And so we'll see. But I think that all these executive orders, a mixture of ones that look bad but legally are not really problematic, with ones that are very constitutionally questionable or legally problematic. And we'll see whether the courts push back. We'll see whether the legislature comes to his aid. Both of those things will be open questions to see how much we're going to have real fiat rule of a president who's the first president to get elected with more military present than an actual audience for his inauguration.
I want to bring this one up to show people that I am very willing to take criticism, because I have no choice when I express myself. Hello, Viva, you made a comment last week, should give the new person a chance. We are not children. To say that Americans whose votes were disenfranchised reveals your total lack of awareness. So suffice to say, I don't think I lack awareness. And Robert and I have been discussing this for months now. When I say give someone a chance, I mean, you don't go in there and try to sabotage things so that you could say, I told you so, because we sabotaged it. You let them start to do what it is that they're going to do. In the same way, governments that we've had here that I didn't vote for, before I start criticizing, I'll wait for them to make a mistake. And as far as I'm concerned, it didn't take Biden administration too long to make a mistake, in that he immediately effected an executive order that's going to have negative consequences on Canada, energy independence of North America, which is going to necessarily benefit the country that shall not be named overnight. Now we have substance that is not just complaining about what has happened, but rather is complaining about what was just done. So
also the process. All these people were highly critical of Trump and he took longer to put in his executive orders than Biden did, and he didn't put anywhere near the number that Biden did. And they said even then that 20 days, 30 days, that was way too fast to put in a major executive order on immigration. You need to go through the process and notice and comment and public debate and And then here comes Biden, and he pushes through 20 plus in 24 hours, and there's not a peep from the institutional media of criticism and questioning. It also tells you all these lawyers who grandstanded and pretended they were defending the Constitution against Trump. They were defending the rule of law against Trump. They will all be exposed as the hypocritical phonies, fakes, and frauds they've always been when they keep their mouth shut when Biden does even worse. And you're already seeing it with people being willing to accept and embrace a patently unconstitutional trial of a private citizen to bar him from future office merely because he was once president of the United States. Even when the Cato Institute, Dershowitz, Turley, people across the intellectual and ideological and political spectrum say there's no such constitutional authority, here you have the Senate marching forward anyway, and many of these so-called rule of law, constitutional law people not saying boo about it or even celebrating it, because they're political hacks who will harlot their legal principles to serve their partisan agenda. They don't care one iota about the rule of law. They don't care one iota about the Constitution. And I'll enjoy their comeuppance as the phonies and frauds they are in the following year, even if I won't enjoy the legal consequences of it.
I'm being called names in the chat. Okay, but Robert, actually, speaking of the Trump second impeachment, am I going out on a limb? Typically, in order to convict on impeachment, you need 2/3 Senate vote.
Correct. And they're playing some games with, if you vote to convict, then the vote to subsequently disbar is just a majority vote after you voted to convict. There's some that are trying to play games that they can still vote to disbar from future office, even if they vote not to convict, which makes no sense constitutionally. So it's just, I mean, it's a despairing attempt to limit Trump in his effectiveness, political effectiveness in the future, and to punish him for ever challenging their established power. They're just willing to eviscerate. I mean, how do these people, like today, George Stephanopoulos was attacking Rand Paul about election fraud, where Stephanopoulos was trying to gaslight the whole country into believing that every single state did its own independent, thorough investigation and determined there was no problems with the election whatsoever. Entirely made up. That's just because Georgie Porgy read the headline of the New York Times, which said, hey, we called up all the state officials and they said they haven't found any fraud. Well, what do you think they're going to say? They didn't do an investigation. Nobody did. The FBI didn't do a meaningful investigation. No independent signature matches were ever allowed. No ballots have been published even yet to this day that I'm aware of, even though they're all digitally scanned and can be, one keystroke. We could all see what the ballots look like. And there's been no jury trial in a single case anywhere in any place. There's been very few bench trials. Those that did take place were were a half a day long, if that, and they changed the standards and rules overnight. The only election contest the president brought, they delayed until after the presidential election had been certified by Congress. So he, dropped it because it was moot at that point. So, but in that same context, they're trying to bring this impeachment trial and gaslight people into believing something that's just not the case. And the same people, Schumer, McConnell, who, standing up for the Constitution is why they couldn't allow a meaningful election contest, even though that violated the plain language of the Constitution and its history, are now turning around and telling you the plain language of the Constitution allows them to do something that nobody in the history of impeachment in any English jurisdiction for 300 plus years has said was constitutional. So, problematic.
Do you think I have a hyperactive imagination when I say that they might actually try to say, well, even if we don't convict because it requires 2/3, we can still vote to bar from office because all we need is a majority? That's
absolutely where they're going. Yes. It's another ludicrous proposition. So different people had proposed to the president suing in advance. He's picked a lawyer out of South Carolina. There are a lot of locals questions about that lawyer. I don't know him. I have no idea about him. So don't know whether he's good, bad, sideways, whatever. Only thing I know is that he has some political connections to the McConnell world. To the Lindsey Graham world, not McConnell. So we'll see. But I mean, it's really ridiculous. I mean, this is like when going back to your statement about giving people a chance. Biden had an easy chance just by taking this off the table because he shouldn't even be present constitutionally anyway. And he did not. He didn't have to rush through on executive orders where he had constitutionally dubious authority, but he did so anyhow. He didn't have to pursue his most aggressive, controversial policy positions, but he did within 24 hours anyway. He did the same rules for you, rules for thee, but not rules for me. On the same day, he issues 4 different anticipated mask mandates of having all the executive branches look at it. He's not wearing a mask on federal property himself. So it's poor form, and it shows where they're at. It shows how completely in denial that they're at, in my view. They don't understand what happened politically, and I'll talk about that more with Richard Barris later in the week. But from a legal perspective, there will be some early constitutional challenges to the reinstatement of DACA, to the immigration issues related to Texas, to these mask mandates once the different executive branch officials put them through. There's also a constitutional question there. Remember when all the media went crazy about how if Trump ever had somebody in a cabinet position that hadn't been approved by the Senate yet? Well, that's almost all of Biden's cabinet people currently. these acting cabinet secretaries that are not, none of them have been approved. I think only one so far has been.
It is enough to make you sick, because it's a double standard. It doesn't matter which side of the aisle you're on. You can either say it's a double standard, but I like it because it's my double standard, or you're on the other side. You say it's a double standard and it's infuriating. I remember all this, and I've lived through it now firsthand as a conscious adult, and I won't forget it. And it's been an eye-opening, albeit somewhat discouraging thing to see. But I want to bring up this super chat because this is an interesting one. Getting back to the conviction and disqualification from office, this will happen now. Whether or not he gets convicted, this is the issue, is that he may not even get convicted by the 2/3 majority of the Senate, but they might still move to disqualify and say, well, he's not in office right now, so we don't need to we don't need to convict on the impeachment, but we can still disqualify. Then we say Senate will convict, then the DQ, then disqualify from running in 2024. Trump will appeal, but the Supreme Court won't hear until it's too late for Trump to run.
And there's several things there. One is apparently Chief Justice Roberts can't preside over the trial because the president's not on trial, which means, that just shows you how ridiculous it is, right? It shows you how the only people that have impeachment power over is the president, not ex-presidents, which Roberts is implicitly recognizing by refusing to participate because he's like, the president's not on trial. And what that would mean is that Kamala Harris could be presiding over a trial that would determine who could challenge her in 2024. And watch all the same people who are like, we're deeply concerned with the idea that Pence could have any role in an electoral contest because it impacts his own future vice presidency, not say a word when Kamala Harris is presiding over who can actually challenge her in 2024. And so it'll be nice to see the David Frenchies of the world, the Ben Shapiros of the world. Many of them have been, grandstanding on the rule of law, keep their mouth shut about a lot of these things over the next couple of years. Ben Shapiro may not be as bad as Frenchie, but the National Review will be atrocious. All these people are a crock. But it'll be good education for the populace base to understand why they should have nothing to do with Federalist Society type lawyers, because many of them are unreliable. But there's several problems with it. One is the Senate can decide up front. They should force it to a vote whether or not they even have authority to do so, assuming that Trump doesn't sue in advance. My advice was to sue in advance, but okay. So, if he should have learned anything from the election lawsuits, always sue early and sue often, because otherwise they may complain down the road. Don't give them that excuse out of the back gate. But they could decide that. Then secondly, if they decide to acquit on those grounds, then they could argue that there's no ability to go forward, and that's a separate issue. Then even if the Senate, by hook or by crook, tries to bar him, that doesn't mean he has to recognize that. He could run and say, you challenger, you say that I can't get sworn in, or you Congress try to prevent me after the American people vote me in the next time. And that would be a problem for them. Would they all of a sudden then discover their constitutional obligation in a presidential election not to go along with what voters think? If they think that it can't be done constitutionally, that would be an interesting level of hypocrisy. But so it's not necessarily clear that Trump himself has to get clarity from the court in advance of his running. He can run and people can vote for him, because what they determined in the McCain and Obama cases was that the states have no authority to take someone off the ballot, even if the state official believes that person is not constitutionally qualified to be on the ballot. Because that was the question in both McCain and Obama. McCain was born in Panama. There was arguments about whether Obama was born within the United States at a time in which that was required for citizenship, because of the nature of how old his mom was. And the court said, no, we can't get involved with that. That's a political question. So doesn't that mean they can't get involved if Trump decides to run and Trump has to be on the ballot no matter what the Senate does, and then force him to take action in 2024? Of course, the president could also either sue before or after. And if the court refuses to get involved, say, well, so what? I gave the court a chance. They didn't. I'm going to run anyway. And let's see what happens. And the local official can't keep me off. So because technically it's not a bar from running for office, it's a bar from holding it. So it doesn't become a constitutional question until he's actually won. I've made this argument in a different context for someone who wanted to be on the ballot, though they were not of age for that particular office. And that's really how the Constitution was constructed, to resolve these kind of matters. But I think the Supreme Court might get involved because there is a comparable that they could always do the political question nonsense. But Adam Clayton Powell in the mid-1960s was excluded from the House because the House didn't want him in, even though he'd won election. And he took it up, and the lower courts were all like, "Oh, political doctrine." They all their Pontius Pilate pretext. Wipe their hands. I can't get involved. Supreme Court overturned. All 9 justices ultimately agreed that it was not a political question. They did have jurisdiction, and 8-1 they said that Congress did not have the power to exclude someone who had been duly elected from the Congress. They could expel him later, but they didn't have the power to bar him. And so you would have a similar theory here. This isn't questioning how the Senate conducts itself. It's, does the Senate have the constitutional power to hold trials on people who are private citizens when the Bill of Attainder provision of the Constitution says they don't? And are we going to enforce that or not? And how many provisions will the court refuse to enforce? It's one thing not to get involved in an election. It's another thing to just completely hide out. They've taken a major reputational hit. So I think the courts would actually get involved. I understand people are like, courts suck, they're terrible, they're on a downer about courts. There are a lot of things to be critical of courts for, but that doesn't mean every court will be bad in every single case. There's just the example we're talking about this week of the German court in a jurisdiction that tends to be more deferential to the government, saying that the local lockdown rules make no sense whatsoever. So there's plenty of places and cases where the courts fight back, and hopefully at some point the courts will if they get enough pushback. But yeah, it's a constitutional joke of a trial, and it makes a constitutional joke out of Congress that they're complicit in it.
Yeah, well, I mean, it's not that I'm listening to only one side of the aisle. I haven't heard any meaningful intellectual scholar say that there's anything justifiable about this, except the only people I hear saying that it's justifiable are politicians and the media. You got Dershowitz, you've got yourself, you've got Turley. I even think Legal Eagle said that there was nothing impeachable about the speech itself, in one of his videos. I haven't heard anybody say that there's anything actually constitutionally justifiable about what's being done. It is, and like you say, you give Biden a chance. Part of me was, saying you're giving him a good advice. Get up on that stand and say, this is unity. Don't impeach someone who got 75 million, half of American votes. But no. And
this is like the Pope in the 9th century who was ticked at one of the prior popes. So he brought out his dead corpse for a trial, because he was still ticked. It's like, that's what this looks like.
Is that true, Robert?
Yes, it's true. I mean, there's even paintings of it, of this corpse dressed up like the old Pope. I mean, he got the bones and the whole 9 yards, the whole skeleton, put him on the defense stand. This makes our system look like like a joke. And the fact that these people in D.C. don't understand that. I was at an event over in Utah last night doing a presentation for a group of people that are, citizens for constitutional government and concerned about keeping government in a limited and constricted by, big, huge crowd, packed out crowd. People were really curious and interested and engaged and want to make change and want to do something. And just by that attitude and the demeanor, Congress has completely misread the country. The country has not responded to, the shameful embarrassments of January 6th. We feel so terrible now we ever backed Trump. We apologize profusely, and we're happy that Schumer and Pelosi and McConnell and Biden and Harris are running the show. It is quite the contrary, is the mindset and mentality that's out in the countryside, and they don't understand it. And this joke of a trial is a classic example of that.
It is. I had said at the time of the first impeachment, I had never seen. I guess I had seen Clinton's, but I was not conscious. I was not informed enough to even know what to make of it. I saw this time around and said, this is clearly weaponizing of the impeachment process to the point where it's no longer going to be the nuclear weapon of political tools. It's now just going to be any ordinary tool, going to be used every time you want to do it. And it's to see this happen now. And it's in light of what the accusation is, makes it even more egregious. But to see this now, to see what they're trying to do now, the only people that can think this is a good idea are people with, I would say, not no conscience, but people who thrive off the divisiveness, or people who are so closed off in by their own blinders and their own silos that they think people actually support this. And from what I understand and from what I've seen, a substantial amount of Trump haters do not support this either. And it's just
Well, they were a classic example is they were interviewing this sort of liberal younger woman type, and one of these local news outlets, and she was like, why are we impeaching someone who's no longer president? She said, this seems juvenile to me. And that gives you the kind of, it's a joke, it's juvenile, it's bitter. It comes across as, Tulsi Gabbard had a very interesting interview with Joe Rogan, where she talked about the greatest disappointment she had with Congress, in part, was how much it felt like high school. It was a bunch of people who had never grew up from high school, and they're still the mean girls, and they don't understand and this is who they are, and this is why our system is atrophying. It's not just that we have people whose moral compasses have long since been broken. It's people who are not intellectually capable of leadership. It's an argument, frankly, against representative government. I've always been more on the little d Democratic side. It's like the problem is what happens when your representative is not representative of the people they're supposed to be representing. The Senate is the millionaires club. Do we think a single senator represents the ordinary person in America, or is representative of the ordinary person? It's hard to see it.
No, and it's not just that. I mean, we've seen it here now. You see the courts, the politicians, and the system as a whole. And it is enough to what's the word? Not to discourage is the understatement of the year, but it's enough to cause people to lose faith. And
I understand that. And that's where I'm like, fire back stronger and better than ever before. That's always the answer. The forfeiture is the only way the other side ever is guaranteed to win. But to be honest with you, it gives me more faith, because these are not worthy adversaries. These are incompetent kids who just need to be put in timeout. And that's who we have running our country. And they just all need a timeout. I mean, when you have someone like Biden who gets one tough question and his response is, come on, man. I mean, you're like, this guy's president? This is an embarrassment for America. So we just got to keep hammering away at it. And I'll be doing that this week on Monday. File a Supreme Court petition for a little guy who stood up to the system, Michael Strickland. And the case will be Strickland v. Oregon. And I'll answer a question that a lot of people have, because people through the years say, why file Supreme Court petitions when they're 1,000 to 1? The odds are 1,000 to 1 you'll ever get one granted. Now, if you dig through a lot of those, my view is it's closer to 100 to 1, because a lot of those are not really raising legal issues. A lot of them are pro se, things like that. If you're a prisoner and you have nothing better to do, you're going to write your own Supreme Court petition every time you get a chance. But you never know which one might sneak through there. You've had pro se petitions actually be granted by the Supreme Court. The Supreme Court likes to prove to the world who it can be in certain instances. Though my favorite ever, little brief tangent, my favorite ever form of relief requested was by a prisoner who requested specific relief. And his specific relief requested was for he went through each name of the people that he felt had screwed him over and railroaded him in the case to kiss his rear end. He wanted the judge to order them specifically to show up at a specific time and place to do so. And so
I suspect that didn't go far. I saw one about a prisoner.
But he must have enjoyed writing it. He stuck in prison anyway, and it became infamous. I mean, it was because he used some other language you can guess to kiss his not just derriere. He used the more crude term, but it was right in the caption. So it was, please, specific relief for these people to kiss my. So I was like, well, why not? It's something you can only get away with in Boston legal. But what we're filing is this. The reason why I recommend filing it is, first, there's not many times you get to talk to 9 Supreme Court justices and 36 law clerks who are likely going to go on to be judges. Some of them Supreme Court justices, many of them law professors, some of them senators or congressmen. So these are some of the most influential people over the course of legal history that we deal with. So anytime I get a chance to write about a substantive, serious legal issue to them, I take that chance. Even knowing that it's 1,000 to 1 whether I can sneak through and get my petition granted. The second reason is You preserve your argument for history and posterity. It's always there. I like to go and read old Supreme Court petitions from the 1800s. Third, you lay out a template to start you trigger a conversation and you lay out a template. I'll be putting this up on my site and the Free America Law Center place once we have it done on a website, in order for people to cut and paste. So for lawyers across the country, and then sometimes pro se people can see, okay, this is what the argument is. And anytime I have an argument that I think people can replicate and duplicate in their own arguments and their own defenses across the country at every level of court, I try to create the legal roadmap for that, the policy roadmap for that, using the Supreme Court petition to do so. There's no copyright claimed on it, and so they can cut and paste and have good arguments made and at least preserve those arguments from a legal perspective, but also begin to educate courts and lawyers and defendants all across the country about what their rights may be in this context. Because in this particular one for Strickland v. Oregon, what happened with Michael Strickland is, he's a little guy who was a photographer, videographer, freelance journalist, has a site called Laughing at Libs or Laughing at Liberals?
Laughing at Libs, I think. And we've done a few discussions on this during streams. I did a video on it. Strickland, yeah. So he's a small, skinny guy. He gotten assaulted at a previous event, got a firearms weapon, legal carry, was being harassed at another event, chased, at some point I believe was assaulted, pulled out the gun, brandished it, pointing it down, said, get away, get away. Everyone lets him get away. He gets convicted on how many counts of and for what?
So he'd been the prior victim of physical assault by people associated with the kind of people that tried to attack him that day. Based on that history of assaults and having his video equipment stolen from him and the rest, he got self-defense training, got his right to conceal and carry, learned how to brandish his weapon for self-defense. And on the day in question, a group of people who later admitted their goal was to beat him up or harass him, not have him present there.
They were seeing it in real time. I don't think there was no doubt about that.
Exactly. Were decided to try to attack him at a rally in Portland. And he's a little guy. I mean, Viva would look very intimidating compared to Michael Strickland.
And so I break 5'6" with shoes on, but I'm well built.
Yes, exactly. And he's a guy that's a little bit on the spectrum. So this was a horrifying event for him to witness, and he tried to follow his training to a T, which was, okay, you walk back, you show them the gun, you don't pull out the gun. They kept walking forward. Okay, you pull out the gun, you show them that you have it, and then you put it away while moving backwards. That's all he did. Nobody was hurt. And because he successfully defended himself, he was arrested. He was charged with 17 crimes. He was charged with unlawful brandishing of a weapon. And at his trial, he was not allowed to introduce any evidence of his own state of mind, any evidence of the history of these people who had assaulted him, any evidence of his own history of being a victim by people like that. And so I took it up to the Oregon. I was hired after the trial, took it up to the Oregon Court of Appeals, showed the Oregon Court of Appeals that the judge's excuse, which was a misunderstanding of hearsay and other rules, simply didn't apply. They would ultimately recognize that, so they changed their standard. And they said, you know what? There's just no right of self-defense in Oregon unless I, as a judge, objectively would have done the same thing that you would have done. And so what that would do is completely gut the right of self-defense. There is no right of self-defense if the judge had to do the same thing, because no judge is going to say that. Almost every criminal prosecution is going to be some politically controversial case. What judge is going to say, yeah, I would have done the same thing they would have done? That's not going to happen. So it basically kills self-defense, period. And so I'm taking it up to the U.S. Supreme Court because an underappreciated aspect of the Heller decision, an undervalued aspect of the Second Amendment, in my view, throughout its entire history, is that the Second Amendment is not fundamentally about the right to bear arms. The Second Amendment is fundamentally about a particular method and means of effectively doing self-defense, whether it's from the citizen or from the state, another person or the state. And that's what it enshrines, and that's what the Heller Court rightly identified. The Heller Court said what the Second Amendment is really about is your right of self-defense, because that goes to the core of the social compact and why we even have government in the first place under the Lockean theory that our government was established under. under the predominant philosophical precepts that we created government. It was to defend one another against each other or against foreign enemies. And so self-defense is the core of it. And if you don't have a right of self-defense against another citizen, another individual, or even the state in certain circumstances, then the government itself is illegitimate. And so my view is the Second Amendment is there because using arms is the most effective means of self-defense, but it's not limited to being able to have a gun on your wall. It's in fact intended to be able to use or brandish that gun where necessary for self-defense.
It's, I mean, obviously we're preaching to the choir because I understand the argument. I know the case, not as well as you by any means, but I understand the case, and it's sort of a no-brainer that there can be situations where the exercise of self-defense is, on the one hand, so exaggerated, disproportionate, unjustifiable, outlandish under the circumstances. Like, you look at a 5-year-old kid and feel threatened and self-defend. Whereas in other cases, the subjective element is not just relevant, but almost critical. And to the extent it's not coupled with a gross overreaction and a gross use of excessive force under the pretext of self-defense, we're within the realm of reasonable interpretations under similar sets of circumstances. And to say that we're not going to factor in the subjective element in a criminal conviction, it seems to undermine one of the fundamental elements of criminal law on its face, which is the mens rea.
Exactly. So we're bringing that as also a due process violation under that it's basically watering down the intent requirement and removing it almost entirely. But really what it goes down to is making sure people understand the Second Amendment is a right of self-defense. And if that doesn't include a subjective component, then there is no right of self-defense. So that's your subjective experiences, your subjective understanding, your subjective interpretation, and the rest. Now, that isn't the final end of it. That subjective action still has to be objectively reasonable in the minds of the jury. We're not challenging that aspect. We're just saying that to completely obliterate every subjective attribute obliterates self-defense, because they're treating him like it's like as if he was the Rock and a bunch of little kids were annoying him and he brandished a gun.
That way, or that, as exercising self-defense, he went out and actually open fire. I mean, you can take a more extreme example where someone's gonna say it was self-defense. I feared for my life, like the guy who shot the Trump supporter in Portland. I mean, yeah, self-defense. If in your mind someone's political affiliation is an immediate threat on your safety, versus people literally chasing you down, taking swings, saying go get him, and we're in different realms. One is irrational fear of self-defense, even subjectively justified to the person. The other one is subjective but totally justified and reasonable and to be expected under similar circumstances. And to not factor in specific elements of the individual, on the one hand, with the entities at issue and also with historical abuse. Yeah, it's I mean, you're preaching to the choir. People in the chats are just saying, I hope you get a fair shake at the Supreme Court if they even decide to read your cert.
They do. I know this from range of sources. They read all the petitions for cert, particularly if it's a decently written petition for cert, it'll get circulated. And if it's a creative idea, I'm also using it as an opportunity. A lot of law clerks helped out in drafting the cert, is to teach them legal writing through a real case. And part of it is use cite policy examples, cite that so in our petition for cert, where we cite international legal standards, reinforce this idea of self-defense being a core human right that's constitutionally enshrined. State courts, of course, have supported this over hundreds of years. History has supported this. Empirical evidence that it's supported by a wide range of data. But citing a wide range of academics, historians, logicians, and lawyers in a wide, beyond just a national scope, to sort of reinforce and reinform the policy that's there. And mostly it's just to lock into their head the idea. They will all get this idea by the time they finish reading it, whether they take any action or not. They will get the idea in their head. The Second Amendment is about self-defense, and that means the Second Amendment informs the interpretation of self-defense everywhere, as state civil law, state criminal law, torts, statutes, you name it, regardless of whether even a gun is used. And that's the part of the mindset I want people to start sort of thinking through. If someone uses a knife and they're denied a right of self-defense because their subjective interpretation and understanding is all excluded as evidence from trial, to me, that's much a Second Amendment violation as when someone uses a gun to defend themselves. And so I want to have the Second Amendment be a constitutionally recognized right of self-defense, which must include some subjective components moving forward. And it's the beginning of that process. And it starts by writing petitions for cert. But I'm not tied up with whether the SCOTUS gives us relief or not. It's about getting that conversation going so that we can have lasting difference. And it's thanks to people like Michael Strickland who've been willing to fight the system all the way through to give us the opportunity to even have the argument presented.
Okay, two questions here. I doubt there is any case that you're not aware of. just in case, though, this one changes everything. Does Barnes know? Remember, the Harold Fish case in Arizona was basically prosecuted because of the caliber of the gun used.
I do not know about it. That's a great name, but I don't know about the Harold Fish case.
Okay, well, we'll look into it. Maybe it'll be a game changer. Second thing, I know people are asking, is there a way to, I don't know how Strickland's paying for his legal fees. Is there a way to support him to support the cause?
Yes. The Laugh at Libs. Is it Laugh at Libs or Laugh at Liberals?
I think it's Libs, if I remember correctly, but someone correct us in the comment section.
So you can support his work directly because he's a freelance guy. So so he's, I believe, still on YouTube. I believe he's also on Rumble. So that's one way you can support him because he's a little independent freelance videographer who's taken some really dangerous, put himself in harm's way, as is evident, has been willing to fight for Second Amendment rights. And there's a group, he'll know there's a group of associations that are backing him that have helped out financially. And then the suit is being supported by the Free America Law Center, which I was part of founding. And so people can go there. It's www.freeamericalawcenter.com. That's where I'll be putting up some of the substantive templates there, as well as my barneslawllp.com website. We'll be putting up a lot more templates in a lot of different places to help the self-education project that we're trying to launch in the new year. So and in fact, the Free America Law Center is busy because it's also supporting our Covington cases. And we'll talk about that next week because we're filing a Supreme Court petition as it relates to Elizabeth Warren next Monday on that question. And then we'll have another Supreme Court petition issue coming up I'll have at least 4 I will file in the first 4 months this year.
Booyah. And what I was going to say was that'll be a good excuse to follow up on the Covington, to follow up on the Strickland. And everybody wants a more detailed explanation, go back and check some of our previous live streams on this. And I did a video on it a while back. So you get more details of the circumstances. You can see the video yourself. Second thing, by the way, before I forget, 10,000 people watching, which is beautiful. Hit the like button so we can see that go up to a lot. But I don't care so much about the like button. Just so everybody knows, I post all of the live streams to Rumble the day after. So everybody can watch this on Rumble as of tomorrow or even as of later tonight. We do this. We transpose the audio to podcast. If anybody wants to get that on podcast afterwards, it's called Viva and Barnes Law for the People. It's on Podbean, all of the big ones, Stitcher, Apple, whatever. You can get us at Locals. vivabarneslaw.locals.com. That's where you can find us. I think that was the major plug that I wanted to do right now. There's nothing else. And now, but Robert, before we forget, one executive order on the gender discrimination. I read it. I read it not thoroughly, and then I read it in comparison to everything that everybody's saying that this is going to be the end of women's sports. I didn't make the connection, although I know why people are making the connection, but is there anything directly in the executive order that actually leads to what I think would be tantamount to transgender men or women, I don't know exactly how to say it, competing in traditional women's sports? Is that in the executive order itself, or is that the logical follow from what people read the executive order as implicating?
Yeah, that the order basically authorizes them to treat it as discrimination to not allow men to participate in women's sports, and that the Civil Rights Division under Biden's Department of Justice will likely follow up on that. And so the concern is that, Obama towards the end was saying that you couldn't even have gender-based bathrooms at public high schools. That's where they were going. That all got halted by Trump. It looks like they're going to fast-track that all again. So it's not just going to relate to sports. It's going to relate to locker rooms. It's going to relate to bathrooms. And the real question is, how broad does it really get? In other words, in terms of for example, women's sports will survive as long as only a few men are participating in women's sports. If, on the other hand, you get a bunch of men who decide to do so, that will then all of a sudden it changes the equation. Because historically there's a wide range of women's sports where people who are born men have a natural advantage, biological advantage. And so if there's enough men competing, or people born as men competing in women's sports, then you're going to have a problem for people born as women to be able to compete.
Well, so did the executive order specifically say the discrimination in the context of sports, or just gender discrimination at large?
At large, and that's why I say they plan on doing it Title IX in general. I find it the crazy interpretation of it. People don't realize that the reason why we have a lot of women's sports is because of Title IX. What does it even mean to have those sports if gender is fluid, is socially constructed fluid? It opens up a wide range of legal and financial consequences if it's really implemented. I don't think this is another area where Biden is doing something that does not have broad support, and that he almost never talked about during the campaign. You didn't see a bunch of Biden ads saying, "Let men compete in women's sports."
But I and it's not to play devil's advocate. I'm just saying I read the executive order. It says that there shouldn't be any discrimination based on gender identity. Okay, fine. Now, to say then that would imply a forced inclusion under penalty of discrimination in sports, I imagine the case would come up to test.
That's because they had already done that. There were some courts in other places that had already done that during the Obama administration, that if gender identity was included as a basis of non-discrimination in the definition of gender, then that would mean it was, in one context, it was a bathroom. They said a high school could not limit a bathroom to men or women, or to boys or girls. That it was, however, they couldn't restrict someone who was a boy, biologically identified as a boy, but who self-identified as a girl. They said if gender identity is included as a part of gender, that's why the executive order doesn't look consequential. It's understanding how it's been previously interpreted that you realize it's a poison pill, potentially. It really depends on how many people act on it, right? Because as a whole, it's been very few men that really, very few people born as men who are participating in women's sports. Transgenderism generally is a very, very small percentage of the population. And so it may not have broad social consequences. And there are large parts of the country where this is not a popular cause, whatever the case may be from a legal perspective. So it's going to be an open question. I'm not a fan of it. I agree with Joe Rogan and others on this, with that their biological gender has a content. It's why we have weight classes in boxing, right? It's not because we want to discriminate against lightweighted or heavier weighted people. It's because there's a biological difference in the ability to make a difference inside a boxing ring based on weight.
Well, so now, and this is where I'm going to come to Cleopatra's chat in a second, so I'll get there. But this is where I had, once upon a time, thinking about the discussion where we're talking about gender identity as the basis for the discrimination, and I can understand that it's nobody should be discriminated against for their own personal choices that affect only themselves. As far as the distinction in sports goes, or even in life, like, okay, gender identity at some point in the near future, maybe a law could be proposed that gender identity is not going to be the defining characteristic. It'll strictly be chromosomes. And so you will not identify as whatever you want, but the distinction as far as sports goes and competition goes will literally be chromosomes. I don't know how you would prove that or how you get tested for that before sports, but I do know that even in some of the Olympic sports, once upon a time, they were testing certain athletes to determine their chromosomes because they thought they had something of an unnatural advantage for the class.
Yeah.
In more recent cases,
Russian shot putters or East German shot putters, for example.
And I remember the case
claim to be women shot putters and whatnot.
Well, no, that's the thing. It's like I remember how I would say embarrassing, for lack of a better word, but imagine someone saying, "We don't actually think you're a woman, and can you take a genetic test to prove that you have the proper chromosomes?" I can imagine that being a little devastating for a person to be asked. But I mean, if that's the criteria, then okay. We're not going to have gender distinctions in competitive sports. You'll have chromosome distinctions, and then in which case, gender identity will never be the basis of any form of discrimination or distinction. It'll strictly be chromosome distinction. But I don't know if that's practical. I don't know if maybe that's where it's going to go. But there was the incident, the cyclist who was a transgender cyclist that just destroyed the field of women. And the irony, the ultimate irony that I just see in all of this is that in furtherance of the protection or the ostensible protection of one set of rights, you end up trampling on another set of rights. And I don't know. I mean, I know women to the extent that they're allowed to voice disagreement on this. Some of them have. Some of them said we're not competing anymore. And others who voiced some sort of public resentment or public disagreement were ostracized and forced off of social media. So we'll see where it goes. I mean, I suspect it's going to force its way into a legislative solution that's going to resolve the issue and not subjective elements of one's own being. With that over, Cleopatra says, "Hi David, hi Robert. You should both move to Florida. Hello Tom Brady, and congratulations to Tampa Bay. See you at the Super Bowl. We have President Donald Trump and Governor Ron DeSantis. Look for DeSantis to run for more than governor next time. Great state, open."
Yeah, I have a 14-1 bet on Tampa Bay to win the Super Bowl, so that's looking good because of their win today.
and I dare say I always pick a loser, and had I picked McGregor last night, I would have picked a loser. I love McGregor, but Dustin Poirier, knowing what I know about the UFC, was never a 3.5-1 underdog against McGregor. They're both great fighters. What was I going to say now? So I think we've covered that. Florida, and by the way, that's what I wanted to plug. My second YouTube channel. Speaking of Florida and the beautiful weather there and the blistering cold we have here, if you want my second outlet to the world in the event that something ever happens to this channel, Viva Family. It's not law stuff. It's fun stuff. And today I did the Impemba effect. When it gets blistering cold in Canada, boil a pot of water, throw it up in the air. It's a glorious effect.
It like freezes?
The vapors themselves instantaneously turn into a cloud, like sort of a mist, whereas the chunks of water don't. But it creates an effect that's just beautiful. So Viva Family, if you want to go check out the second channel. What else did we forget? Have we forgotten anything?
Well, I mean, briefly on, you did a good video on the Amazon v. Parler. The only thing I didn't know about the judge, I knew she was a Carter judge. I did not know the rest. I did not know that it was a she
81
from
years
New York, who grew up in New York City, who went to law school and college in the Ivy Leagues in the 1960s. Basically, if you wanted a demographic profile of who hates Trump and who hates Trump supporters, she is it. So as soon as they got her, they were completely screwed. What was amazing was she made an interpretation of the contract that even Amazon had not argued for. Amazon had said, pretend we suspended and not terminated, because the suspension provision might authorize something that the termination provision did not. She says, I'll just pretend that that the provision about suspension really is termination. And that there's two conflicting, completely at odds termination provisions. And note, she buried that discussion in like one paragraph. The whole core of, she comes up with an interpretation that even Amazon didn't have the guts to argue, which was, hey, we can terminate anybody for any reason we want, basically.
She literally said that in the judgment.
Yes.
It said,
even Amazon didn't try to argue that, because Amazon doesn't want to lose every rational person running for the door from their contracts. But she was anxious, so she made up stuff that even Amazon didn't argue just to gut the case. That's why I think Parler has an above-average Ninth Circuit appeal if they get lucky with the panel. That's the hard part.
Their appeal is going to be academic by this point. I mean, their appeal on the restraining order or the
theoretically, but any relief is probably relief, because at this point they're still struggling to get back up. Amazon can get them back up right away. So, and that if they could get a real 30 days, then they could transition and maintain power. So it's definitely much harder, but there's still a shot, and it'd be worthwhile to do it anyway. But the other thing was the long lectures she goes on, her political lectures. Oh, this horrific day that happened at the Capitol Hill, and these people are saying the balance of the equities favors those insurrectionists. I mean, it was absurd. Her opinion was laughable. It was openly partisan. She should retire. You're too old anyway to still be on the bench. To be an old political hack makes it worse. I hope I will never have a case in front of her.
So I refrained from infusing too much of my own personal opinion in the assessment. I was overtly, stating that this was arguing from a conclusion. It was motivated reasoning, but the lofty manner in which she described the events of that day as though it's a juridical fact, her interpretation was over the top. What was the other thing? What was the other thing that she said?
She cited a newspaper article as if it was truth, that it didn't even support the proposition she claimed it did.
The straw manning of Parler's position, that Parler was asking that Amazon be compelled to host insurrectionist, violent content. That was never the discussion. That was never the argument. That was never anything. In fact, Parler was not. She was saying Parler admits that its content was violating the terms of service. Parler was not asking that they be forced to host illegal content, but rather that they respect a delay within which to allow Parler to remove that which everyone agreed probably ought to be removed. And here's a discussion I had with Nate Brody, another great YouTube lawyer, fun guy to listen to. Nate says they admitted they were in breach of the contract. My argument is you're not in breach of the contract by having objectionable content on the platform at any given point in time. You're in breach of the contract for failing to remove it in accordance with the terms of the contract. So it's not the presence of objectionable content that was a de facto immediate breach. It was the failure to respond to it. And by all accounts, even by Amazon's, they responded to it by and large within 24, 48 hours, which is better than Twitter still. But and she bought into the distinction of the hosting differences between Amazon vis-a-vis Parler and Amazon vis-a-vis Twitter, which I still don't understand the distinction, but I'm suspicious that it's not.
And especially in the antitrust context. To pretend, because the antitrust issue is about whether they have a contractual relationship that Twitter and Amazon are both enriched by Amazon excluding Parler from competing with them. She just ignores that. It was a dishonest ruling. It was a disingenuous ruling. It lied and made up facts. It was a political hack ruling that is that's one of the most embarrassing rulings for any judge to make in a year and a couple of years when we've had many of them, unfortunately.
And I mean, the argument that it's exceptional relief, the provisional injunction, when the balance of equities is on the one hand, respect the contract, give them a window to remove the contact versus remove the offensive content versus shut down the business overnight entirely. You're not going to convince a layperson. You're not going to convince anybody with half a brain that the balance of equities doesn't just tip sharply in favor of one. It's obvious. Given the nature of the internet, it's a no-brainer. Now, the question is, this is a discussion I had with Nate as well. The four criteria, are they elements or are they conditions? Do all four of them need to be met, or can three of the four be met and one becomes less important? My understanding is it's more the latter. You don't have to meet all four criteria, but rather if you don't meet one, it can be sort of trumped by having met the other threefold.
That's definitely in theory. The reality is it depends on which court you get on which day. If they want to screw you, they say all four have to be met. If they want to follow the traditional principle, or if they just want to give you relief, they say, no, it's really just the balance of the equities and you balance the four out. Historically, it's supposed to be you're balancing the four out, and it's supposed to come down to what's the concept. It was best defined by one court case, which said, who suffers more if I'm wrong as a judge? And that's the best way to think of it. And if I'm wrong and I gave relief and shouldn't have, does that lead to a worse outcome than if I'm wrong and I should have given relief and did not? That's what balance of the equities really means. It's risk of being wrong and who should bear that burden and where does that burden lie? And some of that you're projecting things that are difficult to project. But historically, in this context, almost no burden on Amazon, almost none. Whereas as dramatic a burden as possible. And instead, she had to pretend. She took the bait. What we talked about last week, the Amazon's defense was purely political, and she took the bait and ran with it. She was like, the balance of the equities is the insurrectionist may siege power again unless I, the great judge, take action to prevent Parler from existing. I mean, what a crock. When she was walking out of the courtroom, she heard the angels singing hallelujah to her and to all of her majesty. I mean, this is how nuts some of these people are.
I'm trying to find one of the comments. It was a no-brainer. It was the certain paragraphs which went into another judge considering things which were not evidence brought before the court, but which judicial notice of the events of the 6th. Those horrific notes. If that was the issue, my feeling is that this judge probably is not familiar with the internet to know the types of comments that go up there day in and day out. It's an impossible burden. That was the comment. What good was the 30-day notice? It was my argument from the beginning. If you can suspend without notice, and you can create you have no notice period. And to
exactly. And notice, this is a lesson for everybody who watches that will constantly repeat. She doesn't talk about that in any detail. It's a sign of a dishonest judge, a sign of a dishonest ruling, that when a judge won't deal with the main argument in the case, just pretends it's not really there. That if you read it, you wouldn't know it existed. And so it was a sad, pitiful day for the judicial system more than anything, frankly. But I do hope they appeal. If they get lucky, they may get a reversal on this, and it's probably not the end of the story, because her interpretation is just not one that other judges can sign off on lightly. The problem is, once she makes a ruling, it's much harder to get a reversal than the other way around.
Preserving the status quo was the term I was looking for before as well. When you go in with a provisional injunction, it's to preserve the status quo in the absence of a compelling reason not to preserve the contract between the parties, unless there's an egregious, not even an egregious, but rather unless there's a clear reason not to, or a clear breach. But she just went there. Amazon, Parler said this. Amazon, in sworn statements, denied any collusion with Twitter. Okay, good enough for me. By the way,
it was absurd. I think Rakita Law also sent us a chat. Oh yeah, there it is.
Either I said something to P.O. Rakita or Rakita. It's Nick Rakita, awesome channel as well. Implied duty of good faith and fair dealing in Washington. Why didn't they brief it?
They should have hammered that point more. Now, this judge, it wouldn't have mattered. They thought they had an open and shut case on the 30-day notice provision. But clearly that was a breach of also the fair dealing. And I think, in fact, I'm going to be bringing suit against a major bank because of its political discrimination. The OCC, Office of Controller of Currency, put through a great rule that said banks cannot need to make their decisions based on objective factors of risk, not subjective factors of politics, noting that the original legislation that was passed was meant to, the Dodd bill was meant to curtail the Frank Dodd bill was meant to curtail bank problems after 2008, and one of those problems was banks using subjective data rather than objective data to make credit and capital allocation decisions. And now they're just doing so politically. I mean, shutting down, if you're involved with guns, some banks are shutting you down. If you're involved with private prisons, some banks are shutting you down. What got a lot of legislators upset about this is they refused to fund certain oil projects in Alaska that enraged some congressmen and senators. And then, of course, on top of that, now, of course, a bunch of banks are shutting down Trump. The OCC really made that illegal for them to do. But going to Rakita's question, another way for people that can sue that have banking relationships is they do have usually a covenant of fair dealing, of good faith and fair dealing is in most contracts. Sometimes it can be imposed by tort law into the contract effectively in some states, depending on the jurisdiction. There's also tort, like Missouri and some other states have what they call a prima facie tort, which basically just means you did something that we, the courts, don't like, and a jury should decide whether it was right or wrong. So that gives you some broad scale relief sometimes. But the OCC rule was a very good rule. Biden administration is probably going to try to reverse it. A bunch of people are going to try to fight it, but it takes a while to reverse that kind of rule. But it establishes a good evidentiary citation for argument for these other lawsuits against banks that I'm going to be bringing and other people are looking at bringing that are going to be based on a breach of the covenant of fair dealing, of good faith and fair dealing, of which an example is using subjective political partisan preferential prejudice in order to be able to prevent that from occurring. And so we'll see if that takes place.
Okay. And you know what? We're nearing 2 hours, so let's wind it up. Robert, I know people are frustrated with the court systems. I personally, I am as well. Might be why I'm doing this instead of practicing the law. What do you tell people to reassure them as to, to not to have faith, but what do you do to remedy, to rectify what many people believe and feel to be, call it corrupt for lack of a better word, but tainted and inefficient and ineffective judicial system? What do people do to avail themselves of their rights when they feel that way?
Well, the only way to try to get the courts to do anything is to try to bring requests for relief and remedy to them. So, just forfeiting in advance doesn't help anybody. So that's step one. Step two is we've had, and there still are, far worse systems of justice, both in history, both in terms of time and geography. So there's a lot of, there's still going to be a Stickman type decision that happens. There's still going to be, like the German lockdown decision that happens. There's still going to be courts that step up to the plate. And the only way you afford the courts an opportunity to do so is to bring the challenges that can make it happen. And there's going to be state court judges that shut down large parts of what the California governor was trying to do. There were state court judges in a wide range of contexts that stepped up during this context. There's been a bunch of sheriffs that have stepped up during this context. So there's plenty of relief and remedy still out there to be sought, and at least try to get it. And if it turns out that they're completely closed and completely corrupted, then you seek political alternatives and political remedies of replacing those judges, of replacing that system of justice, of going to a different system of justice, and so forth. But at this point, we have every reason to believe there's still opportunity present. And so you might as well keep knocking on the door until you find out. And that's the only way anything changes anyway. So it's always to find the most effective and meaningful means of questioning the system, of criticizing the system. In 1945, there was no reason for the NAACP to think that them bringing a few lawsuits would, within 20 years, bring civil rights to all Black Americans. Because, it'd been 70 years they'd been shut out of the courts by hook and crook. Every means of illicit action, every means of unconstitutional action. There was no reason to think the South was suddenly going to give up and fold. The industrial North was going to give up and fold. But in 20 years, they did. Because people kept knocking on the door, and sooner or later, enough people listened. And that's the only way to make difference, is to keep trying to make difference. And it's the only way I know how. It's the only reason to do so. And I still have full confidence that there's a chance to do so. It's believing something irrational that leads to something great occurring in the end.
And I'm going to bring up John Jalan's comment here because it might be a good last thought for me up for the evening. John Jalan says, "Don't break the law, and state of jail works for me." The problem is when people start weaponizing things that you don't even need to break the law to end up in jail or to end up before the courts or to end up sanctioned for whatever the reason. The problem is following the rules doesn't work when the rules are weaponized to go after anybody and not necessarily even the guilty. And so,
and civil disobedience may be coming back. It happened en masse in Italy this week, where Italian businesses said, okay, we get some politicians are telling us we can't open. We're just going to go open. And our patrons are going to come buy our stuff. And are you going to lock up half the country? Well, what's going to happen is the politicians are going to have to fold. There's a reason why Martin Luther King used civil disobedience so effectively. So there's all kinds of potential sources of relief and remedy. And my part of that is to try to make the court system be part of that. Or when they go too far, like in the Rittenhouse case and in the D.C. case, to get to one of the questions on the locals board, you are not allowed to use bail to impose unconstitutional conditions such as suppression of speech. But there'll be those of us that step into the breach to try to make that difference, and we'll try to get the courts to do what's right, and the rest of us do what we need to do in the interim.
And I will do my best to bring that to the attention of as many people, and so you can know what's going on in the world, and so you can all make your decisions. I never tell anybody to go. Civil disobedience is a personal decision, and with personal consequences. And it's very easy for everybody else to say, go protest, get arrested, and get yourself thrown in jail. We will do our best to continue to raise awareness, to sensitize people to the good and the bad decisions out there. People, take your chances, go to court. And if it's a bad decision, it might set precedent for the years to come for that very reason. So it's just a question of making sure people know good and bad.
Yeah, cases good and bad help shape the world. And so there's ways in which you can continue to fight and resist in a constitutional democratic way. There's no reason to give up on what our forefathers gifted us over 2 centuries just because we've run into a momentary hiccup.
All right. And with that, Robert, thank you very much. Everyone, thank you all for tuning in. You know where to find us during the week. I'm shamelessly back on Twitter, but only for expanding and communicating the word. But the videos, you know where to find us. Watch our content. Robert, thank you very much.
If you want, there'll be a post-thread comment section that will occasionally respond and react to on the Viva BarnesLaw.locals.com board.
All right, everyone, enjoy what's left of the weekend, and we'll see you next week, if not earlier.